Louisa Wall.
Tēnā koe te māngai o te whare. It is my pleasure as a member of the Justice and Electoral Select Committee to speak on this first reading of the Arbitration Amendment Bill. I'd like to commend my colleague Paul Foster-Bell. It is a bill that meets a need, and I want to acknowledge that. And certainly I want to acknowledge the information that we've received from John Walton, the President of the Arbitrators and Mediators Institute of New Zealand. I also want to acknowledge that this whole area actually stems from the United Nations Commission on International Trade Law, Model Law on International Commercial Arbitration of 1985. So it's actually called 1985 Model Law, and it was amended in 2006 and added a more comprehensive approach to interim measures in support of arbitration. New Zealand became a signatory in 1996. It's interesting, the whole issue about model law, which is really about suggested patterns for lawmakers in governments to consider adopting their own domestic legislation based on the framework. So we're actually implementing an international instrument. So well done, Mr. Foster-Bell. I find it interesting, the whole discussion around arbitration versus court proceedings. I've Googled, and arbitration is a private dispute resolution mechanism. And so I think the reason that you've highlighted specifically that it is about confidentiality is that it's a private process, and that process is undertaken by agreement by contract, which is actually why there are limited rights of appeal, as opposed to a court process that we all know is public. And the courts are usually governed by judges and juries, and there are rights of appeal. So those are essentially the differences. I was fascinated to look at the Carr versus Galloway Cook Allen Supreme Court decision, and within that Supreme Court decision, and just as a bit of background, it was a dispute about a commercial property sale. And within that particular arbitration agreement, it included the right of appeal based on questions of law and fact, which in fact isn't part of Clause 5, Schedule 2 of the Arbitration Act 1996. And within that judgment, and I think it's really interesting to note, given actually that seems to be the premise and context for this amendment, that the Supreme Court identified three issues. The first was what constitutes an arbitration agreement in terms of the Act. Can the offending words in relation to appeals on question of fact be severed from the overall agreement to arbitrate? And thirdly, if they cannot, should the award be set aside on policy grounds under Article 34 of Schedule 1 of the Arbitration Act? Because that's in fact what happened. The agreement that was reached in arbitration was set aside. So I think this is a very important piece of legislation. Our Select Committee is incredibly busy, but I don't think we're busy enough to fit in this piece of legislation to our schedule. I also want to particularly highlight the issue between the court and arbitration as it relates to trust issues. And there have been issues lately where families have had to go through very public processes. And as noted in some of the information that I've received, some of those family members, I don't think it was good for their family matters to be aired in such a public way. And so that's what this particular bill seeks to do, is to provide that mechanism of arbitration which allows families to have their disputes. But let's have disputes that are related to family matters in private, and let's let them be confidential. And overall, we want an agreement that is binding on both parties, so that if people go through that process, they can't then go to court and in fact end up starting the entire process again. So well done, Mr. Foster-Bell. There are questions to be answered, but I am sure that the Select Committee has the capacity to answer those questions, and I look forward to participating in the process and hearing from esteemed legal minds, because I'm sure, as Chris Bishop has already highlighted, there will be much interest, and particularly from certain sectors of our judicial system. Kia ora.
Maureen Pugh. My pleasure tonight.